Hello, everyone. This is Kevin Mosher. I am a MSBA certified specialist in labor and employment law, and I am excited to do this is the last webinar of 2019, and it's a really good topic. It is one of those topics where I need to drink a lot of coffee in the morning to prepare, because we are going to rifle through a lot of employment laws and HR topics in the next, 50 to 60 minutes, probably 60 minutes. We're going to try to get through the whole thing, but we'll see. It is never a guarantee with this. But thank you for attending. Really appreciate your attendance. And if you've come to a number of them in 2019, thank you for that. And we've got a whole slew of 2020 webinars, starting with our January webinar, which will be the third Thursday in January. I think it's the 16th off the top of my head. And that webinar will be reviewing what happened in 2019 that was of importance on the HR side of the world, and then prognosticating what we need to look at in an election year of 2020. This is me. And I guess that's a little write-up about me. If you are not on the MyHR Genius program and are interested, it is a subscription-based HR legal counsel program. There's also educational stuff. We do tips of the week and podcasts and all that on myhrgenius.co website. But it is a unique, one-of-a-kind monthly subscription program where you can call Tom Scope as much as you want on any HR legal type of strategic, tactical legal issues that you need, and you don't have to worry about legal fees. So emails too. Okay, so this is more about the program, and then here are the topics we're going to cover today. So, okay, I'm ready. I think I've had enough coffee. I'm really excited about presenting today. So we are going to cover a number of things. So this is what we're going to cover. It looks easy, right? I mean, this is just like 3 little boxes. We're going to do discrimination, harassment, ADA, and FMLA, and FLSA. Any one of these is easily a topic in and of itself. And in fact, I think earlier this year I did 2 webinars on just the FMLA. I think we did a basics of FMLA webinar earlier this year, and then we did an advanced topics on FMLA. So just to give you an idea, we're gonna try to cover a lot here. So fast and furious. And if you have any questions along the way, definitely reach out. And there is an ability, I believe, where you can type in the box and ask the questions that you want to have answered. And if we don't cover them, I will reach out and try to respond to you in response to those questions. Okay, ready? Okay, here we go. Starting with discrimination law. So again, this is more of like a 101. I think I'm going to throw in some tidbits. So if you are a pretty seasoned HR person or a lawyer or risk manager, I still think there will be some pretty good value in it for you here today. But let's talk about discrimination. I think everybody has a pretty good understanding that you're not supposed to discriminate against people. But if we boil it down under the federal law, there's Title VII, right? So Title VII of the Civil Rights Act prohibits certain employers, not every employer, really small employers are not covered by discrimination. I don't recommend it, but at the federal level, I guess if you have 10 employees, you can not hire people based on race, religion, or national origin. It's still a fairly risky practice, and your state might, a lot of states have prohibitions for any size employer on these sorts of things. So I'm not advocating going around discriminating based on race, religion, gender, national origin, color, pregnancy, that sort of thing. But technically, if you're a small business and you go to and you have an employee that goes to the EOC, technically you could defend yourself and say if you have less than 15 employees, then that you're not covered by Title VII of the Civil Rights Act. But if you do have 15 or more employees, and you probably do, then you are prohibited from discriminating on these bases. These are what we call, so I'm going to use this phrase, protected statuses or protected classes. So if you hear the word protected class or the phrase protected class or protected status, we are talking about some sort of status classification of people that is protected by law. Now, some states have things in additional to the federal law. So you're probably wondering, like, why is age not on here? Well, age is covered by the Age Discrimination and Employment Act, the ADEA. That is a different law from Title VII. It also prohibits discrimination, but on the basis of age for larger employers. But a lot of states, not all, but a lot of states have their own human rights or civil rights act, and they will often mirror what we see at the federal level, where you can't discriminate with regard to like race, religion, gender. But a lot of states will throw in other things, just for fun. The big one that is different among the states is sexual orientation. So technically, in a lot of states, most of them being in the southern United States, you can actually probably discriminate against people based on their sexual orientation. Because it's not clear yet, we might, any week now, we might hear from the Supreme Court that Title VII does prohibit against sexual orientation discrimination. But right now, it's not clear that federal law prohibits sexual orientation discrimination. A lot of states, however, do. So, if you don't want to hire somebody because of their sexual orientation in Minnesota, well, that's been illegal for 25 years. If you're in Texas, it's a different scenario. You probably could get away with it. We'll see what the Supreme Court says. There is a case right now before the Supreme Court that is going to make a determination. We expect it'll make a determination as to whether or not Title VII, the sex discrimination, so there's the gender sex discrimination prohibition, whether sex discrimination equates to sexual orientation discrimination. And we'll see. We'll see what the Supreme Court says on that issue. So we need to know, when we're employers, we've obviously got to have an understanding of the federal law, especially if we have 15 or 20 or more employees. But so we have to understand that we can't discriminate. And when we talk about discrimination, what we mean by that is with regard to the terms or conditions of employment. So if you want to, what is discrimination? Discrimination is not hiring somebody because of their race, religion, sex, national origin, age, those sort of protected statuses. It is not giving them a raise. It's not giving them a bonus. It's not giving them a promotion. These are actions that are taken, adverse actions with regard to the terms or conditions of employment. There might be, I can't think of any great examples off the top of my head, but there might be things that have nothing to do with the terms or conditions of employment. It could be, for example, like inviting somebody to a happy hour. If it's not work related and it's just coworkers, is there a potential case for discrimination because some coworkers didn't invite another coworker because she's pregnant or because he's Hispanic or whatever your protected status is? Probably no case there, right? Probably not a good lawsuit because it doesn't impact the terms, or it doesn't materially impact the terms or conditions of employment. Being invited to the happy hour, that's just a voluntary type thing organized by coworkers, probably doesn't impact terms or conditions of employment. If it's a company sponsored, like a holiday party, something like that, well then that would be different. That would be potential issue for discrimination. When we talk about discrimination, there are two types of discrimination. There's disparate treatment and there's disparate impact. You are probably most familiar with disparate treatment. Disparate treatment discrimination is when you discriminate against an individual by impacting their terms or conditions of employment. So you don't hire the person because they're African American. You don't give the female a promotion because she's female or because she's pregnant or because she's old, right? That's disparate treatment. You are treating that individual disparately because of their protected class. Disparate impact is more of like a class action matter. Disparate impact says, hey, your company's policy is discriminatory in its application. So if you were to have a policy that says we don't hire anybody over the age of 45, for whatever reason, you might have that policy. It doesn't sound very smart to me, but let's just say you have that policy. We don't have this policy somehow prohibits people from being hired over the age of 45. That would disparately impact everybody who's applying for that job that's over the age of 45, right? Disparate impact. It impacts a class of people. And there's some examples you can read them here. Most of what we see on a day-to-day basis and what we talk about and we see is disparate treatment. That's your one-on-one, disparately, discriminating against somebody individually. Disparate impact is a bigger HR issue because it means there's potential policy issues that might be impacting and discriminating against people. That's the sort of thing you see in the newspaper. Those are the sorts of things that end up being those sorts of policies end up being potential class actions. So when we talk about discrimination, there are these two flavors of discrimination that we need to understand, and obviously addressing them is very different, and it's important to understand what type of discrimination we're talking about. When we talk about harassment is actually technically a form of sex discrimination. Or I should say this, harassment is actually a form of discrimination. It is a way of materially adversely impacting somebody's terms or conditions of employment. I think we understand sexual harassment, so I'm going to primarily use sexual harassment as the indicator here as an example, but harassment, it does pertain to any protected class. So if somebody tells you that no, I can go and harass somebody because of their race, it's not a good idea. It's prohibited by Title VII, by the Federal Civil Rights Act. If you want to go and harass somebody because you're in Wisconsin and the person's a Vikings fan and the Vikings are terrible and the Packers are better and you all don't like that person, that's justified and that's okay, right? Because it's true, so it's justified that the Packers are better. And so, but it's not a protected, like being a Vikings fan is not a protected class. It's not a protected status, right? It has nothing to do with race, religion, age, or anything like that. So it's okay if it's just, because somebody is like, a Red Sox fan in New York, like that's a problem for them, right? Maybe at the workplace, they probably get, harassed about that. That's not illegal harassment because, New York doesn't have a law protecting Red Sox fans. And I don't think they ever will. So when we talk about harassment, oftentimes what employees call harassment is not actually harassment. So there's like street harassment, like, oh, I'm being harassed, which is another way of saying like I'm being managed by my boss. And then there's actual harassment that is illegal. We care from a risk standpoint, an HR standpoint. From an HR standpoint, we probably are always, 90% of the time, we are probably dealing with this like not actual harassment, but just complaints by people that now know the word harassment is out there and that it gets a response. So they just use the word harassment. Like HR is probably dealing with that 90% of the time. But we really care about the unlawful harassment and making sure that when they use the word harassment that it's not the unlawful stuff. So what are the types of unlawful harassment? And again, unlawful because the person's complaining that their workplace, that they are being materially adversely impacted because of a protected status. Let's just use sexual harassment, sex-based as one of them. So we've got quid pro quo harassment, which I think people get. Like this one makes a lot of sense, right? You do this sexual favor for me, and in return, boom, you get a promotion or a bonus or my eternal gratitude, or the better cubicle in the office. You do this, I will reward you with this. Quid pro quo. I think it's Latin for this for that. This for that. But I'm not sure. But I'm pretty sure. I have an idea. So quid pro quo. I think we all get that. What's harder is hostile work environment harassment, right? So quid pro quo, we get, you do something for me, in return I'll give you something, wink, wink, nod, nod. Hostile work environment is harder because what one person thinks is hostile is potentially another person's, what they think is funny or welcoming behavior. So, for example, to be a hostile work environment, the conduct needs to be unwelcome to the recipient. It needs to be actual conduct. It can't just be like imagined, right? It has to involve somebody in a protected class, like a female or somebody, who's a minority or somebody different religion or whatever it is. And then the person needs to find it offensive. So not only is it unwelcome, like I don't appreciate that what you just said, and that you're talking about me, or that you put your hand on my shoulder, or you kissed me, or you touched me, or whatever it is, like I found that offensive. If the person was okay with it because maybe they had a relationship, or maybe they just always joke around in this manner, then if they don't find it personally offensive, then it's not actually going to be a hostile work environment. We see that more and more, where people are like, yeah, they're okay with it, but then something else goes bad at work, and then suddenly they're not okay with it. And if they're honestly not okay with it, it's okay it could still be unlawful harassment if they're okay with it, like for a long, long time, and then suddenly something changes and they stop being okay with it, then they have to communicate that they're not okay with it. They could still find it offensive. But a reasonable person needs to find it offensive, right? So if you are the recipient and you are like, oh, this is offensive to me, but a reasonable person wouldn't find it offensive, but you did, if a reasonable person wouldn't find it offensive, then it's not unlawful hostile work environment. It's not unlawful harassment. And then here's the big key, and this is where most of these hostile work environment harassment claims, allegations fail to be unlawful. It has to be severe and pervasive enough to affect or interfere with a term or condition of employment. And so if you've got two coworkers and there's like one of the coworkers overly hugs the other one, and it gets to the point where it's just like, hey, I don't like that. I don't want to be hugged by you. And then it stops, or it happens like once a year. The question is that once a year hugging, or the hugging that stopped, was it severe and pervasive enough to affect or interfere with that person's employment? Probably not. And this is where most of them fail. Now, obviously, there are certain situations that we can think of that are severe and pervasive. Normally, touching of a sexual nature that's unwanted is severe and pervasive enough. You touch somebody's genitalia, it's pretty much going to be severe and pervasive enough. But if it's a one-off, there was a thing on YouTube recently where there was a reporter and a guy had like run a marathon, and he came and she was reporting, and he wanted his 5 seconds of fame, and he came and slapped her in the butt, and that's a one-off, certainly severe. He touched her inappropriately, surprised her. It's potentially a battery also under state local laws. But for harassment purposes, if they were coworkers, would that be pervasive enough? A lot of courts would say no. So just touching the butt one time, then he does his little cheer and he goes off. If they're coworkers, a lot of courts would find that wasn't enough to, even in this Me Too generation, that wasn't enough. Now, a lot of employers will still do something about it and fire the guy, which is appropriate because you want to mitigate your risk and get rid of somebody who's stupid enough to do something like that. But that's different. Taking that sort of action is different than finding that the situation is unlawful and that there's liability for the company because of that coworker action. Now, things get a little bit different when we're talking about supervisors. So if a supervisor comes and does that, there could be direct liability, and that's a little bit different. But so much of the harassment, the hostile work environments that we see, we want to look at these 6 elements, right, and to understand and just know that the severe and pervasive standard is very high. Now, I will say the state of Minnesota, for example, and Minnesota's not alone, is looking to water down the severe and pervasive standard. A bill failed at the legislature, has the last 2 years, but I can see a day where the legislature under the Minnesota Human Rights Act gets rid of this severe and pervasive standard. Other states are looking at this. There will be other states that look at this, that lower it. This is all part of the fallout from the Me Too generation, the Me Too movement. And if we don't see the courts water down the severe and pervasive standard to allow more and more of these claims to go to a jury, I think we're going to start to see a lot of legislatures, at least at the state level, do so in particularly in the Midwest, West, and Northeast states. Okay, so like I had mentioned before, no webinar is complete without a sexual harassment reference to Spock and James Kirk. So I don't know if you knew that was that's just a common standard among people that do webinars, that there always has to be a Star Trek reference on harassment. So there's a distinction between unlawful harassment and harassment, and again, street harassment. When we hear street harassment, that is something you want to investigate, but it doesn't. But if you don't get the sense from the investigation that there's a lot there, then you might not have any liability from a legal standpoint. It might not reach the unlawful standard. But most employers, well, first of all, you need to have an anti-discrimination and an anti-harassment policy in your handbook. Okay, that's second of all. First of all, you need to have an employee handbook. Second of all, you need to have, within that handbook, you need to have an anti-discrimination and an anti-harassment policy, and that policy needs to have a reporting mechanism. And that reporting mechanism needs to allow the employees multiple levels. It needs to be in writing, and it needs to provide the employee with multiple levels to report the harassment. There's a federal case that if employers have those multiple levels and they have a written policy, then you get certain defenses on the severe and pervasiveness. You get to argue certain defenses to the court. So you absolutely have to have this policy and a handbook. And if you don't have a handbook, but at least you have the policy and it's distributed and signed off, that's fine. But you need to have that, and there has to be multiple levels of reporting. So it's like, report it to your manager. Well, if that doesn't work, report it to HR. If that doesn't work, report it to another manager, member of the management team, or the senior management team, or the CEO, or the president. But you need multiple levels, and not just one or two people. Why? Because what if one of those people is the harasser, right? Or what if they all are? What if two people are, like, two people on the management team are harassing or did something bad? If there's no recourse, if there's no one to go to, then your policy is really ineffective for that. The reporting policy mechanism is really ineffective. So when we get harassment allegations, we need to understand, first of all, we need to do an initial investigation and intake, right? And the first thing that I recommend is that you get the narrative and get it in writing from the person who is alleging that they either witnessed harassment or that they're complaining of harassment. And most of the time it's going to be somebody complaining of harassment. Get their narrative. We need to understand, get it orally, get it in writing. We need to understand the totality of what they're alleging. And again, 9 times out of 10, it's probably going to be something that can be easily investigated, dealt with maybe, a conversation here or there. It's probably, a lot of times it's not going to be anything. We worry about the 1 in 10, right? And we have to understand, like, is this supervisor get the narrative, find out who's involved, and then based on who's involved, we then want to interview everybody who was witness to it, and then get all, if there's text, there's more and more of this, like, harassment with texts and emails and all that, because people, put dumb things on Twitter and in text and on Facebook and Messenger and stuff. And so more often these days, we've got a document trail. You almost want to just fire the people for being stupid enough to just, like, first of all, like, IM with people about personal issues and stuff like that. Just get rid of them for being stupid rather than even looking at your harassment policy. So we want to understand, is it supervisor? If it's supervisor harassment, if there's anything to it, then we need to understand, is it quid pro quo? Is it hostile work environment? What type of harassment is this? And just know that if it's supervisor harassment, supervisors, managers, they are agents of the company. Your company will be liable if the supervisor harassed, unlawfully harassed an employee, especially a subordinate employee. That will be, your company will be on the hook for that. Hopefully you have insurance or something, or you can mitigate the risk. If it's coworker harassment, it's going to be harder for the employee to impute that the company is liable for the coworker harassment. So, for example, if, let's just say there was some inappropriate stuff that happened in a happy hour after work between coworkers, and one coworker didn't like it, and it's let's just say some touching, some groping, whatever, maybe some propositioning, but one coworker didn't like it. It happened off hours, and the company doesn't know about it. And that employee then, who is on the receiving end, that employee then quits and then sues the company for the coworker's inappropriate behavior at the happy hour. Well, the company is going to defend and say, first of all, they need to have the reporting mechanism. And if they do, the company can defend and say, no, you needed to follow the reporting mechanism and bring this to our attention so that we could remedy and investigate the situation. And if the employee doesn't give you that opportunity, they can't bring coworker harassment. They're not going to get very far with it with the courts. Also, harassment, it's not here on the slide or anything, but harassment that occurs outside the workplace is still something that can be investigated by the company. Just because it doesn't happen at the company during work time, that doesn't mean that it doesn't have a direct impact on the workplace. And so if the employee is bringing it up and they're bringing it to the company, and it's impacting productivity and the relationships in the workplace, it's absolutely fair game for the employer to investigate that. So it doesn't matter that it happened outside the workplace. It might help with the employer not being as liable, but those are different issues. But you still, it's definitely fair game to investigate conduct that occurs outside the workplace. Bullying is, like when I say street harassment, bullying is similar in that there is no law prohibiting bullying, at least not today. So there's no laws out there that says being a jerk or being a bully or badgering your coworkers or subordinates because the Vikings are terrible or the Cowboys are terrible. The Cowboys are definitely more terrible than the Vikings. So that's probably more appropriate. There is no law prohibiting that sort of behavior, right? Like they might get their comeuppance some other day, karma and all that, but there is no law against it. So when we get the narrative from employees and they say, oh, I'm being harassed, blah, 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 okay, that's why we want to get the narrative. We want to understand what is occurring. Is this just bullying? Is this just the employee being upset because they're being managed by a supervisor and they don't like that they're being managed or called out for their bad performance or whatever it is? That's, if that's what they mean, that might be bullying, but it's not unlawful. Now, it doesn't mean that you are excited about allowing it to occur in the workplace. You might very well want to get rid of bullies in the workplace for cultural reasons, and because, hey, if they're bullying, they might be maybe they would actually sexually harass or, racially harass or whatever somebody. Okay, well, we might want to get rid of that person because they're just a walking liability and they're not good for the culture, but it doesn't mean that they're engaging in unlawful behavior. And so oftentimes, especially these days, it's much more common for employers to have anti-bullying and to equate bullying with harassment and to prohibit it in the workplace. And again, we want to see what the policy says, and you want to have a good policy. So discrimination is, so harassment is a form of discrimination. This is a definition. And then retaliation is something we have to watch out for if somebody engages in protected activity. So they complain about being harassed, they complain about their wages, they complain about people, making fun of them for their disability or whatever. That's protected activity. That is them saying, hey, I'm protected under the law, I don't need to be treated this way, or my coworker shouldn't need to be treated this way. This is unlawful. This is not good. That's retaliation, and retaliation is also prohibited. We cannot then adversely impact, affect somebody's terms and conditions of employment by terminating them or demoting them or cutting their wages after they have engaged in protected activity by complaining about something that they think is unlawful. Whistleblowing is another, if we do something negative to the employee after or shortly thereafter, or mainly because they have engaged in this protected activity, that also is prohibited under most of these laws, and it's just not a good practice anyway. Although, sometimes we want to, retaliate against employees when they're making like frivolous complaints, but that's just pretty risky. Okay. We've now had a Yoda picture. I think we have one more Star Wars picture, and then I'm going to kind of be Star Warsed out because I think the new movie comes out in the next day or two, and that's, I think, probably fairly exciting for a lot of us. So, okay, moving on to federal law now that we've had the Yoda picture out. The Fair Labor Standards Act. Fair Labor Standards Act, this is wage hour law, so we're moving on to wage hour. Okay, Fair Labor Standards Act creates a minimum wage. I don't know if anybody knew this, but the federal minimum wage is $7.25, and as long as Congress doesn't do anything, it is likely to stay that way for the foreseeable future. It'll probably be like 2050 before it goes beyond $7.25 is my guess, if even then. The Fair Labor Standards Act, the FLSA, it requires that if you are not exempt from this law, right? So if you're a non-exempt employee, and you're not exempt from this law, and you work more than 40 hours in a work week, you need to be paid 1.5 times your regular rate of pay. That's the overtime standard. It's not 1.5 times your hourly rate. It's 1.5 times your regular rate of pay. The regular rate of pay is your hourly rate, and all other compensation, I mean, there are some exceptions, but all other compensation that you are paid. Now, it doesn't mean discretionary bonuses, or if you've got like a Christmas bonus or a discretionary bonus of some kind, then that doesn't need to be calculated into the regular rate of pay. But if you have some sort of commission or production bonus, and somebody produces, sells enough shoes or whatever, and they get a commission at the end of the quarter, you need to take that commission, you need to divide it by the period that it covers, like the whole quarter. And you need to recalculate that into the regular rate of pay. And if the person worked overtime, then we need to figure out for those weeks that the person worked overtime, we need to figure out what the impact of that commission payment was at the end of the quarter, because it will impact what they should receive more money because of the overtime that they worked in those weeks where there's additional compensation that comes later. That, I think I have it. That statement that I just made, I think I have an entire webinar on just that, figuring out regular rate of pay. So if anybody wants to, I think we're doing one in 2020. In 2020, I'm doing a whole seminar just on figuring out regular rate of pay under the Fair Labor Standards Act. But Fair Labor Standards Act requires that you pay employees a minimum wage, requires that you pay them in overtime at the rate of 1.5 times their regular rate of pay, unless the person's exempt, and we'll talk about what exempt means in a minute. A work week, you need to understand that a work week is not just a calendar week, but the company sets what the work week is. It could be Thursday through Wednesday. It could be Monday through Sunday. That's pretty typical, but it really depends on your company. And whatever your work week is, that's a set thing, and you need to calculate those hours. And again, any hours for non-exempt employees working over 40, they need to be paid at 1.5 times their regular rate of pay. You need to keep records. You need to keep records on employees. For non-exempt employees, you need to track their time. They doesn't need to be a punch clock or anything like that, but time records for how much time they work every day needs to be calculated. You don't have to calculate like I came in at 7:52 and I left at 4:43. Like, you don't need that, although that's recommended and that's best practice that you have a time management system. But technically, could the non-exempt employee just write down, I worked 8.0 hours today? Yes, they could, and they sign off on it, and there you go. That's all it's needed. But the law does require that you have daily recorded time, recording the number of hours that were worked by the employee. And then you need posters and all these sorts of things. Okay, so exempt employees. Oh, the other thing is work. When I talk about 40 hours or like work, it has to be actual work. Could you, so for example, we've got, Christmas and New Year's coming up, and a lot of companies will give time off. I don't think there is any law in the United States that requires companies to pay holiday pay. There might be. I'm not familiar with it. I know there is in Puerto Rico, but I don't think there is anywhere in the United States, the continental. So most companies pay for like Christmas Day off or New Year's Day off or something like that. You don't have to. That's a matter of contract. You're giving that to your employees. Could you pay those employees instead of paying them for a full day, for like if they're full-time employees, instead of paying them for 8 hours, could you pay them at a different rate for holiday pay? Absolutely. Could you give them, here's $25 instead of, paying 8 hours 8 hours for the day? Yeah, you could do that. You're like, here's $25 for not working today. It's just standard. Most companies will either give it off and they'll say, put down 8 hours and we pay it at your normal rate of pay, but you don't have to. You could pay like $5 an hour instead of, if you normally make $20 an hour. You could definitely do that. Because it's voluntary. It's not, quote, working time. Because the person's sitting at home eating turkey or getting intoxicated watching or getting off their hangover on New Year's Eve watching college football and not working. That's not, quote, working time. So we don't have to pay minimum wage. And it doesn't count toward more than 40 hours in the work week. So we can do whatever we want. We can not pay them. We could pay them $5 an hour. We could pay them $5,000 an hour. We could pay them a flat amount. There's a lot of flexibility. Most employers don't deal with it, and also there's obviously some cultural issues and concerns about employee morale, but you have a lot more flexibility than a lot of people think about. Exemptions. I'm just going to talk about the white-collar exemptions. We call them the EAP, Executive, Administrative, and Professional Exemptions. There's also exemptions for commissioned outside salespeople. If you have inside salespeople and you're not paying them an hourly rate, or at least minimum wage, you're probably not in compliance with federal law. There are some exceptions, but for the most part, commissioned salespeople need to be paid. They're only covering outside salespeople. Okay, so we'll talk about EAP in a second. But to be exempt, there are two tests. There's the duties test. The person has to perform the duties that are outlined in the regulations of an executive, an administrative, or a professional employee. And then the easier one to figure out is the salary test. There's the salary basis test, which means the executive, the administrative, or the professional employee needs to be paid on a salary basis, which means they need to be paid a minimum guaranteed amount regardless of how much they work in a work week. And that amount, they have to meet the salary level test. That amount, starting January 1, 2020, needs to be $684. And I know there's a lot there, but here are the three tests. Salary basis test, have to be paid a minimum guaranteed amount. If you're paid less than $684 and like $680 and it's guaranteed, then you're not going to be, the person's not going to be an executive, an administrative, or a professional exempt person. Outside salespeople, lawyers, teachers, taxi drivers don't need to be paid on a salary basis or meet a certain salary level. So there are exceptions there. But for administrative, executive, and professional employees, they need to meet the duties, they need to be paid on a salary basis, and they need to be paid a minimum salary level of $684. It is not prorated because the person works part-time. $684 is a hard number that is not prorated. Honestly, it's moot if the person's, doesn't even matter if the person's not working 40 or more hours per week anyway, because you don't have any liability on overtime. But if you are prorating, you're claiming the person's exempt, you're still going to need them to do the record keeping, punching the clock, and doing all that. Because if they're not making 684 and you think they're an executive, a professional, or an administrative exempt person, if they're not making 684 a week guaranteed, then they're not exempt from this law. So you need to be doing all the record keeping. Okay, and that's starting to 2020. So if you haven't heard about that, then you should definitely call because and look at your payroll to see if there's anybody who's making between 455 and 684 that you're claiming to be exempt, because they're going to be impacted beginning in like a week and a half. Executive, very quickly. To be an executive, it's not just to be the manager and really awesome or important at the company. That doesn't hurt, but you have to manage and supervise 2 or more full-time employees. If you are not managing or supervising 2 or more full-time employees, you are not an executive exempt person. There are a lot of project managers out there that manage projects and not people. They are not executive exempt employees. They have to manage a function of the business, like a department or something like that. Administrative employees have to be able, here's where a lot of businesses overuse the administrative exemption. It has to involve non-manual work. I think people get that. It has to be related to the general business operations. If your administrative people are performing the actual business of your job, that's not administrative exempt. They have to be in a support role, HR, marketing, accounting, finance. Those are supporting business operations. Executive secretary, probably not. The person needs to be able to, in their job, be able to use independent discretion in matters of significance. That's a big thing, and that's very fact-specific. But if you've got administrative people that you're claiming to be exempt and they're not able to use independent discretion in matters of significance, they're not administrative exempt. And again, this gets really fact-specific. We need to look at job descriptions. We need to revise job descriptions. We need to, well, first of all, we need to have job descriptions for all jobs. So if you don't have job descriptions, you need to have job descriptions. That's, that is 101 to begin with. And then these job descriptions are going to help us to understand whether or not the person is properly classified as an exempt employee. If they're not, if they're not exempt, then obviously the job description is still very important, especially when we get into accommodation issues under the ADA. But if they're not exempt, then as long as you can have somebody who's the CEO, and if you want to pay them an hourly rate, that's fine. Like the exemption is something you assert as a company. You assert that this person is exempt. It's your burden to prove as a company. If you want to pay everybody an hourly rate and pay them overtime, that's fine. Department of Labor is not going to bother you about that. Professional employees, this means that they work that you have them working in a job that requires specialized knowledge that in science or learning, and they have to get a degree in it. For example, lawyers. To be a lawyer, you need to have a law degree. Just in case there's any non-lawyers that didn't know that, you have to have a law degree. Engineers, this is why we want to have multiple classifications for engineers. Companies that have engineers, for example, some engineers they'll be called engineers because they've just been doing it for a long, long time, but they don't have a degree. That should be non-exempt. If the engineer classification requires a degree, like an engineering degree, that could be exempt, right? So if it requires a degree, exempt in engineering or science learning. If it doesn't require a degree, I don't care how much. There's no like equivalent of like work experience and learning, work like on the job experience that equates to a degree. That doesn't work here for the EAP, for the professional exemption. So you might need to have different classifications. Accountants need to have, accounting degrees, right? Bookkeepers don't. So bookkeepers non-exempt, accountants exempt. Just, some examples. But professional exemptions, not every business is going to have somebody who's professionally exempt. Again, the duties need to require it. I've talked about a lot of this non-exempt employees 101 stuff. I think I've already kind of covered it, so we're going to move on, although it's always nice to see a picture of Gene Wilder. I already talked about regular rate of pay and how we're going to do a webinar on that in 2020. Travel time, really quick. Travel time for non-exempt employees is not the regular commute. I don't care if the employee is driving an hour and a half or 2 hours on their commute to the company. It's not quote, hours worked. Hours worked is when the employer suffers or permits the employee to work. The commute might totally be terrible. That's on the employee. They don't get paid for that. It's not, quote, hours worked. Similar when the employee is traveling. When the employee is traveling, if they're traveling outside the normal working hours, they might not be, for some non-exempt employees, if they're driving like, from Dallas to LA, then yeah, it's going to be considered, quote, working time. But if they take a plane outside working time, like, say they normally work from 8 to 5 and they take a plane from 9 p.m. to midnight, then they're able to relax on the plane. You don't have to pay them for that time that they're able to relax on the plane outside working hours. But if they're driving to LA during that time, you're going to have to pay them the whole time because, you really can't relax. You really can't relax once you get to LA because, the traffic's terrible and people are bad drivers. Okay, so interesting, and no offense to anybody in LA, but it's kind of true. Interesting facts about the FLSA. So we need to understand there are a lot of like mini FLSA laws, so we do need to look at states. A lot of states have higher minimum wage, obviously, than $7.25, especially states that are north of the Mason-Dixie line. A lot of cities have their own minimum wage as well, so we need to understand those. So if you have employees in like San Antonio or Austin or LA or Chicago, you need to understand there are different minimum wages in those cities, and in like California and Illinois as well, and they're not alone. So we need to understand that there's a lot of like mini state and city level things that you need to understand, and that's why you have attorneys like us to help you with that sort of thing. Okay, the last 10 or so minutes we are going to talk about the FMLA and disability laws. So at the federal level, and I will say this, a lot of states have their own disability, like prohibitions. Like Minnesota has its own Minnesota Human Rights Act. Most states have like a Civil Rights Act that prohibits disability discrimination and requires accommodations and that sort of thing. So you need to understand the states as well. But here we're just talking about the federal. So at the federal level, you've probably heard of it. There's the Americans with Disabilities Act, which was amended about a decade ago, that makes so many people, quote, disabled. And in order to be disabled, they need to be substantially limited in one or more of life's major activities. Now, if you claim that you're disabled because you can't watch the Packer game without getting high anxiety, that's not, although probably true and legitimate, it's not a disability. You might have anxiety in other situations. Maybe you've got a doctor that signs you off. That might be a disability. But just because you can't like drink beer during a Packer game, which is like probably unheard of, but let's just pretend there's like somebody out there that can't drink beer during a Packer game. If true, that's probably not a disability. Disability has to substantially limit one or more of life's major activities. Now, what I don't recommend is trying to figure out if the person is substantially limited in one or more of life's major activities. Unless you are actually a doctor, don't play a doctor. We don't want HR people or managers to pretend that they understand medical conditions. So sometimes we have to get information from the employee to determine this. So here's the definition. Some states, Minnesota mainly, has a lower standard for disability, and so we have to understand that. So the key is with disability. The key is what do we do? Okay, so Obviously, we don't want to just go around discriminating against people because of their disability. It's just not a good idea. It puts you at risk, and you might get sued and that sort of thing. So don't discriminate against employees, or applicants because of a disability, right? The key is, what do we do with that? So if I've got an applicant coming in, or I've got an employee, because you are required to reasonably accommodate applicants through the application process, whether that means like changing your website, your application, like online application process, to make it so that you can accommodate employees with disabilities so that they can apply, or for the interview so that you can make it so that the person with some sort of physical or mental impairment that's disabled can still do the interview. You might need to make those accommodations. With regard to employees, let's talk about this. So we talk about the interactive process because federal law requires that if we are aware that the person has a disability, and if that disability, because they've told us, right, or they've somehow said, hey, this disability is impacting my ability to do my job in some manner, right? Like, this is why I'm sucking at my job right now, because I've got anxiety about more than just the Packers, in the playoffs. So I've got more than, it's not just that, it's like actual anxiety. So I've got something about that, and so I've got some anxiety, and it's exacerbating, and it's hurting my performance. That's why you're yelling at me right now for being crappy at my job. So what do? So we meet with the employee, and we talk about the limitations. Like, okay, tell me about, so as you know, you're doing a crappy job, right? You're crappy right now at your job. Let's talk about those limitations. Like, oh, you've got anxiety? Okay, I hear you. What does that mean? Like, how is that impacting, how is that making you unable to perform your job to meet the expectations? Okay, I hear it. It's anxiety. Great. Go to a doctor. Take the job description. Take the job description, so that this is why you need a job description. Take the job description to the doctor. Have the doctor opine about how your anxiety, what does this mean for the job? Because if you have anxiety and it's not impacting your job, and the anxiety is like only because it happens on Sunday afternoons when you're watching the Packers play, or the Dallas Cowboys, more appropriately the Dallas Cowboys, because they're really bad, disappointing, I should say. If that's your anxiety, then it really isn't impacting your job, right? So I don't care so much. I mean, great, sorry to hear that you have a hard time watching the Cowboys play mediocre football. Sorry about that, but it's not like Monday through Friday. It doesn't impact you. I don't really care. I don't need to send you to the doctor. You're still performing like crap. Like, you're still doing a terrible job here. So I need you to turn it around, right? We don't need to go to the medical doctor. If the person's like, oh, I have anxiety, but it only happens during Cowboy games, okay, great, you're doing badly. I need you to turn it around. If the anxiety in this situation, if the anxiety is impacting their ability to do the job, and they're saying, yeah, it's exacerbated during Cowboy games, but it's like Mondays and Tuesdays, it's just, I'm like all in knots, and I can't talk to customers, and I can't do that. It's like, okay, well, talking to customers is required. Go to the doctor, get some information about it. I need to understand, how long is this going to last? Is there anything we can do? I need to understand what your limitations are, because ultimately for this job, I need you to talk to customers. They go to the doctor. They get some information. They come back. You have another meeting with them. You ask them, okay, what did the doctor say? The doctor said that I should take frequent breaks on Mondays and Tuesdays when my anxiety hits, or anytime my anxiety hits. I should take a 15-minute break. I should go and drink a bottle of vodka and come back to work. Okay, well, we can talk about the 15-minute break. That's reasonable for us. The bottle of vodka, we have a problem with it. We don't want you slurring your speech. It's probably not good for our property casualty coverage, our liability insurance. So we're going to say no to the vodka thing, but let's try the 15-minute break. And if it's like every hour you have to take a 15-minute break, well, that might be unreasonable, but let's see what it plays out. And you implement the accommodation, and you let it play out, and you see if it's working. And if the performance continues to be terrible, and they're not meeting your expectations, then you might go back to them and you repeat. You rinse, repeat until you've exhausted everything. Now, you never have to allow the person to do the vodka thing, right? Because that's a hardship and that's too risky and all that. So we don't have to worry about that. But we have to implement and we keep trying all reasonable accommodations. And if the person continues to not be able to perform, then hey, then there's nothing more to do, and you might have to look at moving them out of that job. They might not be qualified for that job. Okay, I'm going to cover FMLA. Here's my Star Wars thing. I'm going to miss it. It's really good. But anyway, I think you'll get the presentation sent to you if you want, and you can see that really cool Star Wars question. Okay, FMLA really quickly. It covers employers, larger employers with 50 or more employees company-wide. You're a covered employer. You need to do a notice in all your facilities if you're a covered employer, 50 or more FTEs. Eligible employees. The employees, however, might not be eligible for FMLA. In order to be eligible for the FMLA, the employee needs to work for you at least 1 year before they take the FMLA. They need to work in the 12 months immediately before the leave. They need to work 1,250 hours, and they need to have 50 or more employees within a 75-mile radius. So if you have, a facility with 5 employees out in Montana and nobody within hundreds of miles, technically they are not eligible for FMLA, even if they've been a long-time employee with you. What does FMLA give you, or give the employee? It gives them 12 work weeks per year of unpaid time off for a number of reasons. But that's what you get. You get 12 work weeks off. During that 12 work weeks, you need to continue to maintain their group medical benefits if they're on it at the typical eligible employee premium. So if you're probably paying for some of the premium, the employee still gets that, and they get to maintain that while they're on FMLA. Here are the reasons for taking FMLA: birth or care for a newborn, placement or adoption. And you get to take FMLA within a year of when the newborn was born. So technically, they don't have to take it right away. The employee doesn't have to take it right away. They can take the 12 weeks later. With regard to birth or care of a newborn, you can limit it to say you have to take that as a 12-week block. A lot of employees try to come back from birth, and they want to say I'm going to take 8 weeks off in a block, but then I want to phase back into the job, and so I'm going to take I'm going to be 20 hours a week, so I'm going to take half a week of FMLA for 4 weeks until I exhaust the whole 12 weeks. You don't have to allow that. With birth, you just say, hey, it's a one single block. For all these others, for a serious medical condition, you could have intermittent leave where it could be really low periods of time to get to the 12 weeks on an intermittent basis. But at the end of the day, the person gets 12 work weeks per year, and there are a lot of ways to measure a year. It could be a rolling calendar. It could be a rolling 12-month period. It could be on a calendar basis. It could be from the first time the person takes it, and that's just a locked-in date. There's a lot of ways that we calculate how this year is calculated so that we calculate the entitlement to the 12 weeks. But these are the other reasons for taking the FMLA. And then these are some of the details. So if the person is going to take it for a serious health condition, they need to be incapacitated for more than 3 full calendar days. And that's not work days, that's calendar days. So if it's just incapacitated for 24 hours, that's not going to be continuing treatment. If the person receives inpatient surgery, inpatient treatment, then that's fine. They could just 24-hour inpatient treatment. That's another way to qualify for FMLA. But if it's continuing treatment for the person's serious health condition, then they have to be gone for more than 3 days or incapacitated, and then they have to receive treatment from a nurse or a doctor, some sort of medical provider, at least twice over the next 30-day period. Now, it's really close. I had this one last slide, but it's 1 o'clock, so we're going to move on. Thank you. I was a little surprised I even got through the 36 of the, or 35 of the slides. Thanks for your attendance. To listen to it as much as you want. Next month, feel free to register for the next month's webinar. I think it'll be really, really exciting. And then take a look at the list of all of our webinars for 2020. And I appreciate your attendance and attention. And if you have any questions, feel free to email me directly or call me at 651-389-5007. Enjoy the holidays.